But one issue there is whether or not the three judges of pretrial chamber of the ICC acted on probable cause or merely on sufficiency of evidence.
Yes.
But as I said, the provision on probable cause and the judges issuing the warrant are procedural safeguards that are good only for the forum and not applicable abroad. That is the limitation. Our Constitution does not extend beyond our territory. Thank you.
Point I was going to, sir, is really the legal remedy of a Filipino citizen to run to our judiciary, which I asked Attorney Alexis Medina and go to him later. But my point, I think you already read my mind, Mr. Justice, and because you were saying we are not sure whether the judges or justices of the ICC went into probable cause or sufficiency, because we are also not sure if they issued the warrant based on a personal determination of the witnesses or complainants under oath. We do not know whether these are media reports or whether their prosecutors came here and interviewed them. No? So ang point ko, Mr. Justice, if I was being arrested and I'm not sure, I should be able to go to Philippine courts. Sa extradition treaty, sir, judge din naman judge ng US, judge ng UK ang nag-i-issue nito, no? And I checked with the ICC versus the other countries that signed with them. For example, the United Kingdom, no? It is the appropriate judicial officer who will issue the warrant of arrest of the UK. So from ICC, ido-double check pa rin ng ano. Ganon din po sa Canada. The Attorney General will apply ex parte for a provisional arrest before a judge. So it's not the fiscals, it's not the Prosecutor General. The Prosecutor General's job there is to bring it before a judge. Ganon din po sa South Korea, ganon din po sa Argentina, ganon din sa Paraguay at South Africa. That is why if we look at the information of surrender and transfer sa page 8 po, number 8, sorry, not page 8, number 8, nakalagay po dito the date, time, and location of the appearance of the arrested person before the competent national judicial authority. Ang sagot po dito na ang pumirma, if I'm not mistaken, si Ambassador Nilinaw, do not know. So he did not know when he surrendered the former president whether they were brought before a judicial entity. So yun po yung main issue ko, Justice, na ang pagkaintindi ko, kung meron pong dispute sa interpretation ng batas or even sa issue of application of the law to certain facts, a Filipino citizen at any time can run to a Philippine court. But in this case kasi, he was denied the opportunity to run before a Philippine court because he was put on a plane and sent there, no? So even assuming I agree with everything you said now and I see the legal basis naman nung sinasabi nyo, sa akin, that remains to be the question on my mind. Can we deny a Philippine citizen the opportunity to go before a Philippine court? According to General Torre, and he can rebut this later on, is that 8 or 12 hours is enough, diba? But I think mas malaking issue yon kung ang court nag-issue ng TRO within 8 or 12 hours unless the circumstance. I think at the time na the lawyers applied, hindi nga nila alam na isasakay sa eroplano diba? But I leave it there. Feel free to comment, Justice. Ang point ko lang po, I think the spirit and letter of the Constitution is clear. It has to be before a Philippine judge to determine this, no?
In fact, Mr. Senator, the procedure in the ICC calls for bringing the person to a Philippine court first before surrendering the person to the ICC. So if you do not follow that, it can be argued that there is what they call abuse of process, and an abuse of process can be raised in the ICC itself. I think this is what will be considered in the September hearing scheduled by the pretrial chamber. Under the rules, objections to the legality or objections on abuse of process may be raised and resolved by the pretrial chamber, probably at the scheduled September hearing. So this remains still open, even in the ICC. The question of the validity of the surrender in view of the non-observance of Article 59 of the Statute of Rome itself. And the other thing is whether or not such abuse of process is curable. And again, that is debatable. It seems to me that the initial hearing on March 14th done by the pretrial chamber was an attempt to cure the deficiency of the absence of Article 59 procedure, because the three judges of the pretrial chamber in that hearing simply did what a local court would have done. That is, determine that the person is the same person named in the warrant of arrest, and that the person was informed of the charges against him or her. And after that, they said session adjourned. So they merely supplied the defect that the absence of the custodial state's local court created. So it remains whether or not male captus bene detentus will be applied by the ICC.
Yes.
Thank you.
Mr. Justice, yung dahilan kung bakit, yun ang tanong ko, no? The reason for my questions is, I grew up dun sa naririnig mong sa presinto ka na lang magpaliwanag. And after the EDSA Revolution, eto sa bagong Constitution, then the many laws we passed after, addressed that eh. Hindi pwedeng bigla ka na lang hulihin tapos sa presinto ka na lang magpaliwanag. Unfortunately, parang yun ang lumabas, sa Hague ka na lang magpaliwanag. Even if there are defects here. But I just like to express my admiration, the way you explain very fatherly, whether it's in class, it's in the Supreme Court oral arguments, or here. Thank you for your calming voice during these confusing times. Thank you, Madam Chair.
Huling hirit po, Justice, may binanggit kayo ng mga violations locally, and such violations would inevitably incur consequences. What possible violations are there to local law and our Constitution?
The possible violation, Madam Chair, consists in the surrender without passing through the court, what we call extrajudicial rendition. That issue will have to be resolved by the Supreme Court, whether or not an extrajudicial rendition is valid in the Philippines in view of our Constitution. And the other issue is whether or not there is a comma that separates international tribunal from another country. In other words, whether or not the colatilia, subject or pursuant to the applicable extradition laws and treaties, refers only to extradition and does not refer to rendition because of a comma. I look at the text of Republic Act 9851, Madam Chair. Section 17 does not have a single comma. It has two commas. And the two commas are parenthetical commas. They are not separating commas. They are parenthetical because they merely enclose the words, if any. So it says that the Philippine authorities may surrender the suspect to the International Tribunal, comma, if any, comma, or to another country pursuant to the applicable laws, extradition laws and treaties. So the commas really refer only to if any. It is not meant to separate the provision that requires a treaty from surrender to an international court, in my view. So it's not a single comma. Dalawa pong comma yan. Ang function ng dalawang comma in grammar is like a parenthesis.